If I could have everybody's attention, I've got 9:30, and I'd like to call the meeting of the Buncombe County Planning Board to order that is scheduled for August 1st at 9:30 a.m. Welcome, everybody. Before we start today, I'd like for everyone to take a moment of silence in memory of the firefighters that were lost earlier in the week and those that were injured as well. Thank you so much. The meeting has been called to order. I talked to our member Rod Hudgens. He will not be here today. He's got an illness in the family and he's unable to attend. Has everyone had a chance to look at the agenda?
Motion to approve.
We have a motion to approve.
Second.
Second by Mr. Kessel. Any discussion? All in favor say aye.
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 All opposed, no. Motion carries. Thank you. How about the minutes? Has everybody received a copy and had a chance to review same? Are there any amendments to the minutes from our last meeting that needs to be brought to our attention? If not so, do I have a motion to approve?
Mr. Chairman,
Yes, sir.
I do have a recommendation, please.
Okay.
If everyone would go to page 4, the third paragraph down, and about the third sentence where Mr. Kessel indicated he lived in a subdivision that had rentals within it, and he did not think it affected their property rights. That doesn't make a lot of sense because what it does, it's not that you didn't make sense, Bernie, don't get me wrong, but the discussion before that is left out. And it's where I was talking about that I knew of subdivisions that had lost 50% of their value because of the economy. And I was expressing at that time my concern that if this proposal for vacation rentals went through, there would be a further devaluation of the properties. And I think if the staff goes back and looks at the tape and reviews the wording, you'll see my discussion. And if you insert something in there about my thoughts on the 50% issue, then Bernie's statement then makes sense as a follow-on. So I would, I wouldn't attempt to recount my exact verbiage, but I would respectfully ask the staff to look at it and insert something in there. And if that delays the approval of the minutes, then, Mr. Chairman, I would request that we do that.
Okay. Let me ask you something, Joe. I'm reading the same sentence. I think it's probably, aside from what was left out that prefaced this comment by Bernie, it looks to me like it may be incorrect anyway. Bernie, let me know if it is. It says Mr. Kessel indicated he lived in a subdivision that had rentals within it, and he did not think it had affected their property rentals. It should be property values.
Yeah.
You see that?
And that would further clarify it.
Okay. How would you propose, Joe, to insert or clarify, insert, I guess, what you said?
Well,
you had some language.
I trust Jillian to pull out. My main point was that I'm aware of subdivisions who have lost 50% of their value because of the downturn in the economy, and that I was concerned that inserting vacation rental zoning into these subdivisions would further degrade the value.
Okay.
Obviously, it's not exactly the way I said it, but that's certainly the intent.
Okay, can you make that adjustment, Jillian, please? Given that that's made, do I have a motion to approve as amended?
Motion to approve as amended.
Mr. Hughes made the motion. Do I have a second?
I'll second.
Ms. Woods seconds. Any further discussion? All in favor, say aye.
Aye.
Aye. All opposed, no. Motion carries. Thank you.
Thank you, Mr. Chairman.
Thank you, Joe. The next item on the agenda is a zoning map amendment request from Danielle Robinson. She has applied to rezone tax lot pin number 9732011650. It's also known as 101 Farida Drive, currently zoned single-family resident District R1 to R3. Debbie, could you give us staff's report, please?
This is an 8.58 acre tract, and it is located on Farida Drive, which connects to Aiken Road just south of its intersection with Goldview Road. The property currently is developed with a double-wide mobile home. The surrounding area contains large tracts of undeveloped land and residential development that's zoned R1. The requested rezoning would not be consistent with the Buncombe County Land Use Plan update, as the update indicates that R3 zoning is suitable for higher density uses and mobile homes. The proposed R3 zoning would allow for uses that are currently not allowed in the surrounding area, and that includes mobile homes, telecommunication towers, mobile home parks, multifamily, and travel trailer parks. And it would be detrimental to the surrounding community. Therefore, the Planning Department is recommending denial of this requested rezoning. Staff has received several phone calls, the majority of which are opposed to the rezoning, and we have received 4 letters, which we've supplied with you. Those are opposed to it as well. And then we received a petition this morning opposed to it that does have 26 names on it. Most of those objections are that the request is for the entire tract of 8.5 acres to be rezoned, which would allow for, with the multifamily and mobile home park options, a much higher density use of the tract, and that Farida Drive itself is one lane and not suitable for a high volume of traffic, and also that it would allow for mobile homes and mobile home parks.
Okay, thank you very much. Who is here on behalf of the applicant that would like to speak and present the application?
May I say it?
Yes, sir, please. And speak into the microphone, and if you don't mind, give us your
I
name.
am David Plemons, the owner of the property
Okay.
that's in question. And Danielle's my granddaughter, and she just married. And she made the application for a permit to put her a single wide on the back point of this property in question, and was denied because of zoning. And I feel, as the property owner and the grandparent of this young lady, that she should be permitted to start where she can afford to start.
Mm-hmm.
This land, I inherited part of this land to the right of the property in question. I inherited the 4 acres there and my home that I live in now. And I bought the other part from my sister that lives in Florida. And I bought it for the purpose of my children being able to use it. There's been some misrepresentation of the truth. We have no intentions of multiple living quarters or a mobile home. In fact, I could have put a mobile home park in there years ago if I'd wanted to do that. I wouldn't do that in respect to my daddy. And I've kept the property up. In fact, I'm a mini farm. I'm registered as a farm. I bought the property and paid for it, the extra property, and paid for it by working the land. And as my dad did, he owned the whole farm before we split up this whole thing. And this is misleading. This 60-foot right-of-way that's through here. This is not a development. It's at a distance from Goldview Road, and it joins. If you see right down here at the point, if you've got a copy of this, you see right down here at the point of the right-of-way where Farida Drive starts, there's just a pencil mark. That means we've just got a 15-foot right-of-way into the 60-foot right-of-way that we left when we split the farm up. And it is a one-lane, self-maintained or resident-maintained road into that. And many of these people that are here today, they pay nothing to the maintaining of that road. And all we're asking is a permission for our granddaughter and her husband. He can't be here today because he had to work. He works for the city of Weaverville. Both of these, Danielle's in school. She's planning to be a nurse. She's studying to be a nurse. And all they want to do is have a place to start. Young people can't start at the category that we that's been working at it 50 years. The housing bubble that's busted is because of people trying to live above their means. And all they want to do is live within their means on property that my family's owned since 1940.
Before 1940, my property was bought later. In 1940.
Yeah.
I was 2 years old when we moved here.
That's one of my brothers there.
Okay.
And we've lived there and worked that farm with the old-time pitchforks all of our lives.
And I own the first property that you got the right-of-way on, the 60-foot right-of-way. My brother, older brother, had it put in there in case the state, if enough people moved in there,
Excuse me if
then
I'm,
the state would have the right-of-way to build the road.
I hate to interrupt you, but this thing is streamed through video and this, that, and the other, internet. What I need, if you want to speak on behalf of the applicant, I'd like for you to come up and state your name as well, just a matter of keeping the record straight, if you've got anything else to say. But we heard you. But you're welcome to come up and speak
No,
too.
I don't need to speak, I
Okay.
just come to help her get her place to live.
Excuse me, go ahead.
And our simple request is just that, and I have no plans, in spite of the rumors that's been spread around. Well, I've farmed the land since I bought it for 20 or 30 years, and in fact, a lawyer suggested one time that we put in a mobile home. I said, no, sir, it'll not happen. Mobile home park. But some people have to, well, everybody can't start at the top.
Mm-hmm.
Everybody wasn't born with a silver spoon in their mouth, and some people have to work it out, and they do plan to build. They plan to build a home, but they need a place to live and start now. And actually, there's nothing wrong. Some of these folks that's here, some of their folks live in trailers. Just beyond my property, just across the branch, one of our neighbors lives in a trailer. A beautiful place. Nothing wrong with it. I've got nothing against it. We have trailers all about us. And I don't understand really how we got zoned in R1, considering the right-of-way that we have, considering it's a private maintained road, unpaved, considering that we've got a asphalt plant within a mile of it. We've got Volvo that digs dirt all night sometimes. We've got rock quarry, and we've got dynamite plant. On the other side, we've got the county prison. It hadn't been long since a sheriff was running in and out of our driveway, and I stopped and asked him what he was looking for, and he said he's looking for a prisoner that had escaped. And he said he's down in these woods here. And I said, well, you can't catch him running up and down the road. He said, well, I can't get down in there. I said, I can get you down in there. And I took him down in there on a tractor. But my plea is, and I appreciate you folks considering, appreciate your time, but my plea is that you alleviate this property, not so I can build a multiple home, and it may never be developed as long as I own it. I still own the portion that I'm going to. And my son lives right in that corner, and he's got a beautiful place over there. And his daughter is his only daughter, and she just wants to be there, wants to have a home there next to her mom and dad. That's a reasonable request.
Okay. Anything else?
I was speaking about the prison,
Yes, sir.
and we used to have the dump, and we've still got the garbage traffic in our community constantly, and the streets at times filled with trash. And I don't know, I don't know most of the folks that's here, and I don't know whether they're here against it or for it. And I contest those signatures. They were gotten under false pretense, false information. We did not ever plan, and her request was not for a multiple home or a trailer park, just a starter. And some of these folks, their kids started in trailers. I think my kids got the same rights. Should have. I don't know if they do or not anymore, but they should have the same rights that our neighbors have. And actually, this neighbor stuff is just pitching neighbor against neighbor. I've got nothing against none of my folks back through here. Nothing. And I've tried to be a neighbor. And actually, they ought to buy the land out if they want to control it. I'm finished, sir.
Okay, thank you, sir. Appreciate it. Thank you very much. What we'll do now is we'll open the public comment regarding this zoning map amendment request. Each of you, if you'd like, would come up and speak for no more than 3 minutes. And if you do, please come up and identify yourself and where you're from. Would anyone like to come up and kick it off? Either pro or con. Yes, sir. Come on up.
My name is Carol Rice, and I live on Goldview Road. And I'll start off by saying thank you for letting us have a voice in the rezoning and of this property from R1 to R3. Also, I want to thank our county commissioners and our zoning committees that I don't know where y'all were involved in when we had the county-wide zoning. And I want to thank them, everyone concerned, for getting us county-wide zoning. It's something that we needed. And I say that to say this, that I am strictly opposed to rezoning of this property from R1 to R3. David and I have been friends, grew up in the community for years, and it's nothing about neighbors, and it's nothing about. I just want to reiterate the fact that this petition that had signed, I took around and had it signed, and it was not under false pretense. I want David and his family to know that. It was merely, it states on the petition from R1 to R3. That's it. And those people signed that based upon the fact they did not want R3. So, and this is why I'm opposed to it. I've been a real estate broker for 25 years. And previously, for 12 years before that, I was in mortgage banking. And I know what an area of R3 zoning can do to the value of the surrounding property in R1. We all know that. Properties' values are reduced. I mean, I'm sorry, I hate it, but it's nothing that I have against anybody. And I know a lot of the property owners say, and I've heard it said all my life, it's my property, I pay the taxes, therefore I should be able to do what I want to with the property. I'm sure everybody's heard that. This is the feeling, in my opinion, of no concern for the fellow property owners or the property values or the environment. This would be like saying, I purchased my car, I pay the taxes, therefore I should be able to drive the car any way I want to on the highway. Same thing. There are laws and zoning to help protect everyone. And that was the petition that was signed. I will say again, I do oppose the rezoning of this property. And I hope the committee will see fit to turn this rezoning down. Thanks.
Thank you, sir.
May I respond, sir?
No, sir. Right. No, sir, not right now.
May I respond to that?
You can come up and speak under the same rules that we talked about a little while ago. But if you don't mind, identify yourself and where you're from.
Okay.
You've got 3 minutes.
I'm Ursula Clemens.
Mhm.
I'm part owner of the property. I'm also Danielle's grandmother. And concerning the petition that was signed, I received several phone calls from people in our community that asked me what the zoning was about, that they were informed that we were going to put a mobile home park in that 8.5 acres. And they just wanted to know why we were trying to rezone that property. And I expressed to them that Danielle had gotten married and wanted to move next to her dad. And most of them that called, although I did not realize that we had to go through the community and get signatures, and we just thought it would be a simple request. And I told them, and they were not opposed to it. And we are, right now, our property is adjoining Brenda's property, and she put a mobile home on her property, so that means our value of our property has went down because of her mobile home being there.
It's a double wide.
We have, well, it's the same thing. They have that all included. We couldn't put a double wide in either. And our sister-in-law, my sister-in-law lives right in front of us. She's an elderly lady, a retired nurse. She lives in a single wide. That's all she needs. She doesn't need a $125,000, $150,000 home that she doesn't need. She's happy in her single wide. She's able to move about. She's 85 years old. She's able to move about and do her own work and keep her house up. We have up above us, next to us, a brother-in-law that has a double wide. We have a niece that has a double wide. There's another double wide, plus there's 2 or 3 single wides back in there. And all these people keep their property up. All these people have moved in before you people decided to rezone us. And as far as Mr. Rice is concerned, his property does not even adjoin ours. He's on the other side of the Goldview Road, and whatever he wants to do over there is his thing. He can do whatever he wants to do with it. And so therefore, when we get calls from our neighbors in our community that are concerned that we're going to suddenly stiff them and put a trailer park in to devalue their property, I think that's a very bad mistake, because we are not going to do that. We have children, and most of them have bought outside of our community, and they probably don't ever want to come live in our community. And I don't blame them.
Thank you, ma'am. Someone else like to come up and speak? Well, excuse me just a second. He stepped up and was coming out, but you are going to, yeah. How about, if you don't mind,
Go ahead, you can speak better than I can.
either one, you can come next. Both of you can come.
Speak well enough for everybody to hear.
I would like to thank you for the opportunity to speak here today.
Your name, please?
My name is Jim Hurst.
Okay,
And
thank you,
I
sir.
am a neighbor and owner of an adjacent property. I'm actually the owner of 2 adjacent properties, and I am very opposed to this rezoning. This is a bad idea. It's bad for the neighborhood. It's bad public policy. I'm not against my neighbors, but I think we have to look to the future, and I think we have to look towards what this opens the neighborhood up to. Because once this land is rezoned, the genie is out of the bottle. This landowner or any future landowner gets a whole lot of options that really aren't available now, and they're not compatible with the neighborhood. And that's not fair to those of us who've made our homes there and made investments in this community. It'll hurt a lot of other families just to advantage one person. And I made a pretty substantial investment in this neighborhood since Buncombe County did zoning in 2009. And part of the reason that I was able to do that was because I felt that the neighborhood was protected and had some advantages that way. This is a permanent change they're asking for that can't really be undone. It'll change the character of our neighborhood. And any future landowner could build duplexes, multifamily units, clubs or lodges or vacation rentals without needing any further permission, and that's not something that's an option now. This neighborhood is not a place for clubs or lodges or out-of-town party houses. It's a quiet, low-density neighborhood, and this change would allow up to about 100 new dwellings on a single parcel, since R3 goes to a density of 8 units per acre. And we have room for a few more houses, but we don't have room for 100 more. Some of the land uses that might be allowed if this change was to take place would be dog kennels and sewer plants and pumping stations and cell towers and travel trailer parks, and that's just not appropriate for this neighborhood. We don't have city water, so we depend on wells for our water. If a developer got control of this parcel, they could put a high-volume well in there and drop everybody else's water level, and wells could go dry. That's a very expensive problem to have. This property is on the very lowest part of the Farida development. It's up against Blue Branch, just a few hundred yards above the French Broad, and the water quality of Blue Branch is pretty good. That would certainly go down if high-density development were ever to happen. And traffic would also be a problem. This neighborhood is served by a one-lane gravel road that's pretty narrow and twisty. The easement is squirrely. I've had trouble looking up the easement in the deeds, and there's some cloud in my mind as to exactly how that easement works. It's just not suitable for high-density housing. And I think wise men from St. Thomas Aquinas all the way to John Locke have argued that the role of government is to provide the greatest good for the greatest number of people, and this zoning change offers benefit to one and takes away from a lot. So I don't think it's a compatible land use for our neighborhood. Thank you for this opportunity.
Thank you, sir. Appreciate it. Yes, sir. Would you like to come up?
No, you should be saying anything. I'm just gonna do what I'm gonna do on my property. Don't matter what it's R1, R2, R3, or 4, 5, or 6.
Okay.
Don't make no difference.
Okay. Would anyone else like? I just wanted to give you an opportunity to speak,
You know,
but apparently you don't want to, in accordance with the structure we've got set. Please identify yourself.
My name is Brenda Rhodes, and I own and live on the property that joins the land in question of being rezoned from R1 to R3. Also, I helped organize the signature gathering on this petition, and it's very clear on here where it says, "We, the undersigned, are concerned citizens who urge our leaders to act now to oppose the rezoning of the property and not allow it." So nobody can say they really were coerced into signing this, because I think the petition speaks for itself. And first of all, it wasn't misrepresented, because when you go from R1 to R3, it's my understanding, it don't matter if you put one single wide or multiple single wides, it opens it up for that. And that's what we're opposed to. So, first of all, I'm opposed to it because it depreciates the property. It allows single wides, like I say, whether it's one or several. It also allows multifamilies. It allows mobile home parks. It allows the cell towers. It's all specified in that agreement. And this property that is in question is very visible from my home, and there are no other single wides in view of my house. And I think the reason of countywide zoning was to prevent things like this from happening, and I appreciate that we have it now. And another thing I wanted to do, that I have a cousin that is in China. She's a missionary. She owns the tract of land beside of me. She submitted a letter, Ellen Walker, and this property adjoins hers, and she makes it clear her intent in that. And I just wanted to make sure that Junes did receive the email, and I think we submitted a copy of it also.
We did.
Okay,
Yeah.
all right. But anyway, thank you very much for hearing me. Thank you for your consideration.
Thank you. Anyone else like to come up and speak?
I always get mad, so I'll
Okay. Yes, sir.
I know what the property was given to the family for, or their family. Whatever way they want to use it.
Please state your name.
My name is Danny Buckner, and I live on the corner of Patty Lane and Goldview Road. And I just want a moment to speak to the integrity of this petition. This petition was presented to me just like it was presented here in this room. I was told that that he wanted to put one mobile home there, but it would open the door to put multiple mobile homes there. So I think the petition was presented accurately whenever it was brought around. There was a question about the rock quarry, the asphalt plant, and the
Junkyard,
powder plant, and the junkyard. When zoning was done out in this area, those were already there. So they were probably grandfathered in. They didn't come in after the zoning. So I think that's pretty well a non-issue as far as this request. Also, I might bring up the fact that my next door neighbor is right now under order for violating the zoning ordinance. She turned her house into a multifamily dwelling, and she's under order by the end of August to turn it back to a single-family dwelling or risk having her power cut off. So this is where zoning does work, and I'm not in favor of rezoning this property to R3, and I appreciate your time.
Thank you, sir. Is there anyone else that'd like to come up and speak? Again, please state your name.
My name is Linda Michelle Wright, and I live on Goldview Road, and I actually live across the street from Brenda Rhodes, and I can see her property from my house. I am having my house refinanced right now, and my property value has held up even in this crummy economy. And if we have mobile homes, single-wide mobile homes that I can see from my house, that's going to do nothing for my property value. That's going to do nothing for our neighborhood. So I am opposed to rezoning this. Thank you for your time.
Thank you very much. Is there anyone else that would like to come up and speak? Can he respond?
I think that would be up to the board chairman, if you would like to allow them an opportunity, since they are the petitioner, to
Okay.
have a last word as to why.
Okay. Yeah, come on up, if you will. Limit it to 3 minutes, please, sir.
I'm not trying to be hostile or anything, but some of these folks that started in mobile homes themselves and right in my face, I mean, they've done what they want to do right in my face. I can see their properties and see the imprint that's made on their property right in view of my home. My land is kept up. I've maintained it since I've become the owner of it, this particular property. Farmed it and kept it in grass. In fact, it's being hay's being mowed off of it at the present time. And I feel like that just the corner of that I'm in control of that property. I'm in control of whether or not there's mobile homes come in there. And as far as the Mr. Jim's got a mobile home just across the street from me. He just bought one. If he was against mobile homes, he shouldn't have bought the property that had one on it. And Caroline Rice's children started in mobile homes. He put them behind the bushes, but they're possibly in mobile homes today.
They're all double wides on.
That's okay. Please, hold on. Yeah, please, let's keep the, excuse me. Hey, we're not here to discuss that. I want to hear him, allow him to finish. You took some of his time. Out of courtesy, please let him finish it. You had your chance, okay? Go ahead and finish, please, sir.
Those young and starting, and I've never opposed anything that they've done. I'm not opposed to people using their property, and I would not and haven't I'm a farmer, and if I'm not mistaken, when zoning was implemented, they told me that farms were exempted. I'm sure they're not exempted from building codes, but exempted from some of the regulations of the, and I am a farm, got a farm number. And I still request that you allow this young couple to start where they can afford to start. They can't keep up with the Joneses, and it ain't our intentions, and I've never tried. But I have tried to be a good neighbor and keep the property. In fact, my property is kept better than any about me, including Mr. Hirsch, his property. So I request again that you give these young people an opportunity to start their life. They've just got married. She's studying to be a nurse. He's a regular worker. My son they'll own the end of the property, and he's a repairman for heavy equipment. Works long hours. Got a beautiful place over in the corner there. And actually, if the mobile home was put in there, it's practically unviewed by anybody. It's back in the corner of the property, and it's not near as in view as some of their properties. Thank you, sir.
Thank you, sir. Would you like to come up and speak? Again, please state your name.
My name's Caroline Hurst. I'm a resident of 113 Farida Drive. We also own a rental at 104 Farida Drive, which is a modular home. We have put extensive time into upgrading that. I used to work for Habitat for Humanity, and their mode of operation was not a handout, but a hand up. We would be handing out our lives here. I have pictures. If he wants to talk about maintaining property, he leaves his farm equipment at the entrance of our driveway. Pallets. Where's the respect in that? I'm looking for a little respect on the future of our investments. Thank you.
Thank you. Come on up here. I've been waiting on you to speak. How about identifying yourself? All right, identify yourself, please, sir. My name.
See, this places, all these places, I guess they're arguing about, except the Rice's
Could you give us your name, please?
It's Blaine L. Plemons.
Thank you, sir.
I own the first lot inside Farida Drive.
Okay.
I've lived there for 20-something years in a double wide. I've had to repair it a couple of times, like the ceilings fell in twice. And I spent a lot of money on it, and stuff. But still, it's a double wide home, and I raised my 4 young ones in it and got one of them back, and I may get the rest of them back in a single wide. You know what I'm saying? Because I've got the same amount of property except for the right-of-way that my brothers, the rest of them got, But what I'm saying is we got it all divided up, and it's supposed to stay in the family, unless if we sold it, we're supposed to offer it to somebody else in the family. That's the way it was given to us, really. And the thing of it is, if we wanted to raise our people in it, our kids wanted a place to build them a house or put them a trailer, whatever they wanted to do. My daddy lived in a single wide trailer, by the way, and I see nothing wrong with that. He had a 3-story house that he gave to me, but it's too big for me to repair whenever I was starting. I couldn't afford to repair it. It was old Jim Waltney place, and it would have cost 10 times what a double wide cost to repair it. But it's on top of the hill where my older brother got to put the 60-foot right-of-way through the bill for the property. And I pay taxes on all that, and it's mine. It's deeded to me. That property is. And I pay taxes on that. And I don't complain about it. And this guy here keeps the road up. Now here. And he ought to be able to do whatever he wants to do on his property. That's my feeling about it, you know what I'm saying? And I've worked since I was 15-year-old and just retired this last year because my wife's sick. And if I want to bring one of my family up here from Wilmington or wherever they at to live next door to me, I'm going to do it, you know, if it's a fight. Because I will do it. And I know people from, I run stores in Hendersonville, and I know the lawyers over there, the judges, and if I have to do it, I'll bring them here. You know what I'm saying? To do what I have to do. And that's what he's doing. So I don't see no reason why that you can't live in a neighborhood. We never asked none of our neighbors to move in there. We ain't never bothered any of them. I treat them just like I do my brothers. And will, you know, as long as they treat me right. And I won't close the road unless that happens now. If I can't have what I want on my property, it's all wooded mostly. You know, and I give trees away to people that wants to cut down a tree or something.
I've got to ask you to wrap it up. Your time's through, if you don't mind, sir.
That's my opinion about the whole thing, see.
All right. Thank you very much. Anyone else?
And I'll help her move her trailer
Yeah.
in.
You've already spoken. Come on up, please, and identify yourself. Give us your name, please, sir.
Petitioner.
My name's Ronald Clemens,
Okay.
and I'm I guess the one that signed the petition's daddy.
Okay.
And I just want to ask, is there any way that you can zone just like that piece of property, or do you have to zone the whole area? You see what I'm saying? In other words, just that piece of property, can it be zoned R3 and the rest of it stay the way it is?
We're going to have a conversation in a few minutes about whether or not.
You know what I'm
R3
saying?
becomes
It's just
spot
that
zone.
piece right there.
Yeah.
I mean, I have nothing against what these other people want to do. You know, I mean, I don't. I just. I mean, I was the one that paid to get this hearing had anyway. I mean, I paid the $200 to get it done, and I just. I mean, I just hate it for. You know, that I stirred up the whole neighborhood because of something I wanted to do, you know, for my family, you know, but I don't think it's right for me to have to bow down to what other people want on their properties, what I'm saying, you know what I'm saying? And as far as the farm equipment and all that stuff was there, that stuff belongs to me. It don't belong to my daddy, it belongs to me. But that stuff was there before any of them people moved in there. I mean, I was farming. I've been farming for 30 years, ever since I graduated from high school. I farmed. I farmed that place and other places around. And that farm equipment's been there. It's been on my place for 30 years. I've lived there 50 years. I mean, you know, all my life, that's where I was raised. And I don't see that I have to go ask anybody around me if I want to put my daughter a place up. I just don't think it's right for other people to mash me in the mud because maybe they are one step higher than I am, you know. But I've worked all my life for what I got, you know. And as far as the Hershes go, if me and Daddy hadn't assigned the right of way, the papers, they'd have never been down there in the first place. I mean, we had to sign to get them to get even enough money to put the place up. I mean, I don't understand what they're fussing at me about stuff, you know, that, I don't have nothing against nobody, what they want to do on their place. And, I mean, if they don't like houses and mobile homes, well, that's perfectly all right with me because that's where I started was with a single wide. I mean, I couldn't afford nothing else, you know. But I just wondered if we could just get that one piece of land because I'm not going to put a mobile home park. I just want one place for my daughter to live, you know, and that's all I was wanting, just one place for her to live. And I don't understand why other people have to knock somebody else out of doing that.
As Scott said, after we close this public comment period, we'll be having a discussion, and I'm sure that's going to come up and probably hopefully answer your question.
Well, I
about
just,
whether.
If other people around me want to keep their zone 1, that's fine with me. I just wondered if.
Okay, that'll be part of the discussion. Thank you, sir.
May I come again, sir?
No, sir. No, sir.
Well, I just wanted to say,
No, sir.
I will deed that end of that property to my son and his daughter, if you just zone that little corner. He's on that little corner.
Well, we'll get it in the discussion period later, and that'll come up. Yeah, please identify yourself.
My name's Wanda Rice, and I live at 130 Goldview Road. There has been discussion about R1 and R3. My understanding was that R1, when our kids, we gave some of the family property, they're talking about family property. Well, this is family property that we live on too, that's been passed down from generation to generation. But our children do have double wides on a solid foundation, and they are on, their own road, access to their own road and everything. It is off of Goldview. But my understanding that you could do on R1, now maybe you can help me with this, R1 allowed double wides, but it did not allow single wides. So our kids were starting out just like she's starting out. Matter of fact, our daughter's a single parent with a 10-year-old when she moved in there, and she has a husband that no help whatsoever. So we know what it's like not to have any money to get started on. Our son also has a double wide. It is on the property. And the reason why it was double wide was because they told us that we had to put double wides because it was R1 zoning. My sister-in-law, Brenda, she does have a double wide. It's not a single wide. All of them are double wides. And she had to go with the R1 zoning. So from my understanding, that R1 you could put a double wide, but you could not put a single wide. So that's the reason our children had to go to that extra expense. It would have been a whole lot cheaper for them if they could have put a single wide, but they were trying to keep the community and the other houses' value around them up, because their land maybe one of these days, will be more valuable if they comply with the rules and regulations of the zoning board.
Excuse me, sir. I'd like to ask the staff to clarify the exact allowance, because I don't think that they call it a double wide allowance now on R1. Can you say exactly what is allowed?
R1 allows just site-built and modular homes.
Site-built,
Back
okay.
In '07, when we had a previous zoning ordinance, R1 and R2 did allow double wides that met certain specifications as far as setup, foundation, roof pitch.
Okay. Well, we followed those rules.
But those are not in effect now.
That's changed.
I know, but when our children developed
Just wanted to
this,
clarify that.
that we were told that we had to have this, it had to be on a solid foundation, the pitch and everything. So we did follow the zoning board's rules when our children went in there. We did put double wides and solid foundations like was required. It cost them a little bit more, and we had to help them a little bit to get started, but we did it. And so that's what all I like to say is that our children did it, not that they're any better than anybody else, but we would like to keep, the whole community up to an R1 zoning, and I appreciate the time.
Thank you. I can't allow you to come back up. You've spoken, and I'm sorry. I apologize, but we've got to get this thing pulled together. And I'd also, you're welcome to come up. I'd appreciate it when other people are up here talking, don't talk over them. My wife accuses me of that all the time. And I listen to her most of the time anyway. But that's all I'm hearing out of you, is number one this time. If you would, and the rest of you, please don't talk over top of somebody. Give them some courtesy. Okay.
Did you want to speak, ma'am?
Yes, come on up. Yeah.
My name's Danielle Robinson. That's my grandfather owns the land. When we did this, we were told that we were only able to have modulars and stick-built houses. We asked about double wides, and they told us that we couldn't have them. So that was my understanding. So that's the reason we're challenging it, is because we can't afford a modular or a stick-built house. Thanks.
Okay. Thank you, Danielle. Yes, sir. Please come up.
I'll talk to you later on. It's been a visit.
Again, please state your name.
My name is Larry Merrill. You know, this is a kind of between a rock and a hard place. I have 120 acres out in Leicester that I own. My great-great-great-great-grandfather was Adolphus Gudger, who was the grandfather of the Gudgers. We have an appeal on one side for what a family wants to do for their family. And nobody can fault them for that. We have on the other side, and I go back to 1975 when Roy Trentham, Carrie Owen, and Kurt Radcliffe first proposed zoning. They almost got lynched in the process. It was a heated discussion. But what we have is this zoning to protect not only these folks, but the other folks of the county. It doesn't always go the way we want. We know that they want to put a single wide in there for their daughter, or granddaughter. But we know it's not about what they intend to do, but it's what's allowed by the regulations. And these things, because there's emotions involved, can become heated. And we mountaineers are fiercely proud of our property. My property that I was raised on, the Gudger property, goes back to about 1815, where I was raised. We're fiercely proud. But we have to understand that times change, that these type things are there to protect not only their property, but other property, and oftentimes it does infringe on what we can do with our property. And I just urge them to go back and look to see, it does allow a double wide with a permanent foundation. If they can work out some way to be able to compromise that, because I hate to see neighbors against neighbors and talking out of turn when it doesn't matter what they intend to do, but it's what can be done and what the potential is there. I appreciate all them, both sides. I appreciate you guys for sitting here and listening to it. I don't have a pony in the fight, but I just felt like that I wanted to give my opinion.
Thank you, sir. Well said. Okay, is there anyone else that would like to speak that hasn't spoken? I'm sorry. Well, having seen none, then I will cause a close to the public hearing portion of this process, and then we'll start discussing it as board members up here. One of the things I think you need to be mindful of is whether you're opposed to zoning or not. We've got a set of rules and regulations we have to go by, and I think it was pointed out several times by Mr. Hurst was one and several other people as well, is this rezoning to an R3 classification opens up Pandora's box. And that's, we've run into this before, obviously, in the years of service we've had up here. I've been here about 2.5 years, I think. And Scott, you've been here for forever almost, this type of thing. And what we're bound to do, of course, is to go by the rules and regulations and this type of thing. I did notice in the map the piece of property that you've asked to have rezoned R3 is surrounded by R1s. You know, and I'm speaking personally here now. I mean, you know, we're looking at rezoning 8.3 acres for a single wide, or I don't care what's single or double wide, whatever. And that wouldn't prevent a future property owner or anyone else, or you for that matter, from, and I know you said you wouldn't do this, but opening up a mobile home park. So that's kind of, anyway, that's the considerations we've got to have, and I know you understand that. It's the other uses that could happen on this property down the road and this type of thing. But having opened up with that comment, I'd like to kind of go across the board here and see if anyone else has anything else they'd like to say.
I think the board members know that I probably, of anyone here, have strong feelings about affordability in this county and what zoning can do to impact that. And I want to say that R3 is a class that they have developed that would allow single wides and now double wides. That's the first class, and I'm sure that's why you've come forward, and I understand. Pulling out one piece to do a single zoning is still going to have the same problem that we face just on the way that zoning works and rules that we have to follow. Having one particular zoning code in the middle of a bunch of them is not something that we've seen in the past legally is able to be done. That's one point. That it's called spot zoning. It's an individual request for one parcel amongst a lot of others, or that could be interpreted that way, and that's a concern. They changed when they redid zoning again. They changed and took off the manufactured options, and on the other side, I have been, and everyone here knows, a strong advocate for lower income homes in this county for folks like that y'all's trying to start in life. And I want to say again, I hope that they look at this, because we have seen this consistent request for R3, which opens up a lot of other uses for folks who can't afford a modular or stick-built home on their parcel. And there's no other way that they can ask to have that done. I really, really, really wish there was a way we could think about that, because we consistently see these requests coming forward and neighborhoods in turmoil, and that I don't think is going to stop. But I will say, I don't see how we can change the zoning of this particular parcel given everything else that's going on, and it's a shame, in my opinion, because I like to see young people be able to afford to live in Buncombe County, not another county. So I would say again, I hope that whoever is looking at zoning and changing zoning at some point, different things you can and can't do, that we work through this problem again, and that we figure out how we can offer affordable housing options in lower zoning codes for people. But as of right now, that's kind of where I am on that. I just want to throw that out to the board, okay?
In the original ordinance, as I recall, R1, it was a permitted use in the first zoning ordinance, and R1 and R2, and it was changed. And I mean, the fact of the matter is there are still a lot of places in this county in which residential, low-income mobile homes and whatever else, there has to be a place for that. There has to be a place for low-income folks to be able to get a start, as you said. Mm-hmm. The fact is that this board is a technical board. We have to look at the issue, and I know there's a huge amount of emotion in this room. Mm-hmm. But the fact is we have to look at it technically. What's the law? How do we interpret the law? And how do we actually apply the law? We will make a recommendation. When we vote today, it's a recommendation to the commissioners, and so the commissioners basically make the ultimate determination. But like Michelle said, the fact is to go from R1 to R3 is a huge jump. And we have to look at it from the standpoint of not what you want to do and what you commit to do with that property, but what could be done with that property if it goes to another, to another owner. And so, I mean, I'm kind of like her. I'm also not convinced that this probably wouldn't rise to the level of spot zoning, and I think that has to be considered. I hate it too. I mean, the fact of the matter is that folks have to have a place to start. But at the same time, from a technical standpoint, I just don't see a way. Mm-hmm. And I'm sorry about that.
One thing that Scott pointed out that's very important is, again, we're an advisory committee in this type of thing, and whatever we recommend will go before the county commissioners, and they have the final say. They have overturned us a number of times since I've been on this board. So, this is not the final say here today. I want to make sure you understand that. regardless how it goes. Let's hear the others as well. I'm not sure. We've heard from two. And how about anybody else?
Mr. Chairman?
Yes, sir.
It may be worthwhile for the residents that are here, who I commend for being here, whether you're for or against a proposal. A lot of times we have these meetings and no one shows up for anything.
Mm-hmm.
And then decisions are made and people complain, but it's kind of like voting. If you don't vote, you don't have a right to complain. So we're really glad to see you here. There's a table in this zoning ordinance that explains what's allowed and what's not allowed. And I just would ask my colleagues to tolerate me a minute and let me just go down and describe what would be allowed in R3. And we understand your intent, but this is what we have to base our recommendations on. And if somebody else became the owner of the property in years to come, this is what they could do as opposed to what they can't do now. The multifamily dwellings would then be allowed. You could have mobile home parks. That's a conditional use, but you could have it. You could have planned unit developments. And a planned unit development is a collection of businesses and condominiums and restaurants and things of this nature all put together within a planned unit. You could have that if it was conditionally approved. You could have clubs and lodges. Those are permitted in R3. You could have government protective services in there. Conditionally, you could have hospitals, nursing homes, assisted living facilities, retirement communities, those kinds of facilities. You could have kennels, and you could have an airport landing strip. That could be allowed in there. Okay? You could have libraries. You could have private recreational facilities like bowling alleys, skating rinks, country clubs. Could have radio and TV towers. And at least for now, you could have the vacation rentals. And you could have travel trailers and travel trailer parks. So when the board rules on its recommendation, these are the kinds of things that we have to consider going forward. And that's not out of disrespect for what you want for your personal family. Please understand that.
Mm-hmm. Thank you, Joe. Well put. Anyone else?
Well, this saddens me. This is a case where zoning is inhibiting your right to use your property that you've worked hard for, and I hate that. Whether we like zoning or not, it's currently in place in Buncombe County, and so therefore we have to make a determination accordingly. And in this case, it appears to me that this would be spot zoning, which is not allowed. So regardless of your intent, based on current conditions, I could not be in favor of the R3, and that does sadden me. I hate that for you.
Okay, do we have any other comments? Okay, having heard none, is there a motion on the floor? Someone like to make a motion?
Regretfully, I'll move that we accept staff's recommendation for denial, that it's not consistent with Buncombe County Land Use Plan, and that since it's suitable for higher density uses, and that it would not be reasonable and would be detrimental to the adjoining properties and property owners.
Okay, Mr. Hughes has made a motion to deny the applicant's request. I have a second.
I'll regretfully second that.
I have a second by Ms. Wood. Any other discussion? Okay, all in favor of the motion indicate by saying aye. Aye. All opposed, no. Regrettably, the application is denied. But like I said, this will go to the county commissioners, and they have overturned us in the recent past. So you'll have an opportunity to talk to them as well. And thanks everyone for your time and input today. as Joe said, lots of times we have these meetings and folks just don't show up. And so we appreciate your time. Thank you. Thank you. Yes, sir.
It can be, I think it's
I'm sorry, I can't, you know,
just
I've been in
offering
management all my life.
It did allow it, yeah.
Thank you. Yeah.
Wish you the best, yeah.
It's not scheduled yet, but we'll send out notifications. Yes.
It just depends
Yeah.
on the commissioner's agenda.
Or they're going to encourage them to open up.
Big change.
Not acres, what are you going to do?
They might I can't put it. I might have to set up.
Nice to meet you, Mr. Clemens. We got to get on to business. It's nice to see you, sir. You have a nice day.
We got another item, believe it or not, controversial. This one's been going on 6 weeks.
3 electrics.
Thanks, sir. Good to see you.
Thank you, sir.
Yes, sir. Good to meet you.
Thank you.
Nicely done, Tom.
All right. All right. All right. We ready to move on to something non-controversial? Something easy? Oh, Lordy. Okay. All right. All right, the next item on the agenda is the continued discussion of zoning standards for rooming houses and vacation rentals. Since our last meeting, at which both Debbie and John weren't able to attend, as you guys know, we've had considerable discussion regarding the issue. Lots of emails, as you know, this type of thing. And again, I'd like to see this thing wrapped up. But what I'd like to do is open the floor to John and let him comment on the direction that we've been heading over the last couple of months, and give us his spin on it and recommendations as well. He didn't have an opportunity at the last meeting to give us his recommendations, so I'd like to allow him to do so today.
I think I've heard from several of you, had some conversations over the last couple of weeks about the discussion that went on at the planning board meeting 2 weeks ago. I guess at this point, we had put some wording together for you initially. There had been discussion about that. Then, as I understand, that Mr. Hudgens at the last meeting talked about doing conditional in R1 and R2 and in Beaver Dam. And I think that, the talk goes back and forth about, okay, which direction do we head? And that's why we didn't really prepare anything for you today, was to, continue that discussion that we've had in the past. One is that if we're going to do conditional uses in those areas, we've got to put some conditions out there. It's more than, what we've seen today. We don't want to get in a situation where the neighbors say, I just don't like it. At some point, and I think the county attorney would be more than happy to weigh in on that, is that we're going to get ourselves in real trouble. I think there's, some questions about what has happened in the legislature and how that deals with vacation rentals and being able to enforce and inspect and everything else. So I just want to kind of bring it back today and I guess hear what you all have to say about, what we need to do and what the discussion was the last time about, do we head down the road of conditional use, or do we make some changes in the existing recommendations to go ahead and allow these things at a certain number of nights? And I just kind of want to hear what everybody has to say.
Okay, if you don't mind, Debbie or John, either one, let's kind of start over at first base. Restate the existing language. When John made a comment about just tweaking the existing language, at this point, the vacation rental definition is what I'm talking about.
They're allowed in.
Well, both.
Okay. Well, the definition right now, it would be that it would be no more than 2 single-family homes with a combined total of no more than 9,000 square feet and that are rented for 2 days or more to tourists, vacationers, or similar transients. And the language right now would allow those in all of the zoning districts. There is also a vacation rental complex, which is more than the 2 homes or more than the 9,000 square feet. Those would be treated conditionally in R3, neighborhood service, commercial service, employment, public service, Beaver Dam, and open use. So not allowed in RLD, R1, and R2.
Okay, now when you say the language is presented, I think that's the way you said it. You're talking about the language that, because I call it the 2-day minimum rental piece. That's the language that has been presented.
That was what was presented at the last meeting.
Okay, all right, with the conditional use piece.
No, without.
No, that's right.
With
We asked
permitted
you to go back.
in all the residential districts.
Okay.
And I have that language if anybody needs it.
Yeah.
I think I have it, but just to make sure I'm looking at the same thing.
Debbie, can you clarify something for me regarding the 2 units?
Mm-hmm.
What happens if I own vacation rentals? Does that apply if there are 2 units on one parcel or 2 units on contiguous parcels? Or what if you have 5 units spread across the county?
Well, it's 2 units on one parcel, and then with the vacation rental complex, it is, where's that part?
Combined more than 9,000? Okay. Or 10 units or more? Is that right?
We discussed that, and that's why we added a group, meaning if you have, like, say, 5 single-family homes adjacent to each other, that would be a vacation rental complex. We wouldn't consider if someone owns one up in the north part of the county, one in the south, one in the east, one in the west, separated from each other. We wouldn't
It would not be a complex.
No.
Okay, good.
Mm-hmm.
Have to share a property line, is what you're saying?
sorry?
I just said, I was confirming you'd have to share a property line
either.
to speak to the adjacent language. Is that
Either
correct?
on the same property,
Mhm. And
or 5 houses in a row, 6 houses in a row, 6 cabins.
5
in a row.
lots that shared the same adjacent property line would be a complex due to 5 units, correct? Okay. And you wouldn't get into complex unless you were over, if you were 3 or more, am I reading that right? And or were more than 9,000
square feet.
Or if you were more with 9,000 square feet?
Yes.
Okay.
So if you had 2 houses that were 5,000 square feet each, that would be a vacation rental complex. Or if you had a 10,000 square foot house, that would be a vacation rental.
Okay. Okay, looking at the revised permitted use table, looks like vacation rentals would be permitted in all zoning districts, whereas vacation rental complexes would be conditionally permitted R3 down or up, whichever way you look at it, commercial, neighborhood service, et cetera. Is that right?
That's correct.
Okay.
As we go along, we need to not forget the Beaver Dam area. Most of the discussion I hear talks about the R areas, but we have Beaver Dam, which is every bit as much a residential area as these other areas.
Mm-hmm. Yeah, well, Joe was looking at this table number 1, and which shows that it'd be permitted in including the Beaver Dam area across the board.
Mm-hmm.
And whereas for vacation rental complex, it's conditionally allowed in Beaver Dam, but not so in R1 and R2 under this current proposal.
Correct. That's correct.
And that's for the steep slope overlay as well.
Mm-hmm.
For the
So I'm a little puzzled on that. Why the complexes would be allowed in Beaver Dam but not R1, R2?
R1 and R2 tend to be smaller lots and higher density, whereas Beaver Dam there are larger lots and a lower density. So a vacation rental complex, we're only talking about more than 2 homes, more than 9,000 square feet. That's a more intense use for an area that has small lots and a higher density.
So they can be pretty sizable units then, or complexes.
Well, we start our limits at 3 single-family homes or greater than 9,000 square feet, or 2 single-family homes that are greater than 9,000 square feet.
Yeah. So it could be
No limit to the square footage.
No, but it would be subject to the Board of Adjustment's approval and meeting those conditional use standards that we placed in the language.
And that's number 13 on the one we got.
Mm-hmm.
Section 78678, conditional use standards applies to the complex, right?
And just to point out, the protected ridge overlay, we didn't allow vacation rental complexes as an allowed use. And then for the steep slope high elevation, we put a limitation on the number of units, and it's conditional where it would be conditional in the underlying zoning districts.
Okay. Well, we're at the same spot. We need to create some language and go forward with some language to be published for the purpose of a public hearing soon.
With regard to conditional uses, what limits, I mean, with the new statute that's out there, what conditions can you put on the property that would not violate that.
I think that is a good question, and there's no real hard and fast answer that I can give you as to, legislation talks about permit, and you don't know whether they're talking about zoning permits or whether that legislation is talking about, like a business license or, something like that. So you're kind of going to be taking a leap of faith, but you really don't know what the legislature actually intended. So that's probably going to be something that will be argued out in the courts. That's something that we have a concern. While we don't think that it was the intent to prevent zoning and prevent that type of thing, we're just not 100% sure. And so I can't give you a definite answer. I think the more definitive you are and the less permit requiring, I think the safer we are in terms of being successful in it if somebody would challenge the zoning ordinance. The more permit-oriented type of regulations we have, I think there's greater room for a person to challenge that.
Could it be something as simple as reviewing the existing restrictions on property where the property actually lies to determine if they're in compliance? Such as someone trying to do vacation rental in an area that actually has a limitation, but they're going to do it. They've been doing it anyway. Could it be used to give an enforcement vehicle to deal with that?
I just don't have a definitive answer for you on that in terms of, well, I think a lot of it's going to depend on the facts that you're dealing with.
I mean, in reality, if we're going to do conditions, they need to be meaningful. If we're going to have conditional approval, if the purpose of having a conditional use permit is simply to give the surrounding neighbors the opportunity to speak, then I'm not sure what value the conditional use is.
One of the problems I have with the conditional use statements here, and while I'm opposed to this whole thing from the outset, as everyone knows, when I look at the conditional use, though, I just don't see where any place wouldn't qualify because the conditional use is so loose. For example, look at paragraph A. The development shall have access to a highway or road. Well, what does that mean? What does suitable mean? Suitable for the scale and density of the development being proposed. That is really subjective, and I would not want to be on the Board of Adjustment having to make these decisions. In paragraph B, it talks about shall be 20 feet or otherwise specified by the Board of Adjustment to ensure adequate air, light, and privacy. What is adequate? What's adequate to you? How about adequate to me? Paragraph C, access to a public or private street. Again, what kind of access? Adequate vehicular circulation. Acceptable levels of access for emergency vehicles. What does all this mean? So I agree with Scott. I think if you go over on the other page, you've got the use of adequate again. And if this board recommends to the commissioners this proposal and conditional use standards is significant or should be made significant. Otherwise, any place would qualify for this based on the wording I'm seeing here, because it allows such broad interpretation.
Okay, anyone else?
I spoke out in the last meeting in support of the conditional use per Rod's recommendation, and I would like to rescind that basically for a multitude of reasons. First of all, it's bothered me ever since. I don't believe that was the right thing to do personally. And second of all, it seems like we're just going to create more problems than we are good. So I would like to rescind that. further regarding the vacation rentals, I'm in favor of staff's recommendation for permitting vacation rentals in all zoning districts.
Okay. Anything else, Josh? Thank you, Josh. Bernie, you got anything?
Well, I think my stance on this is pretty clear. I'm for it being permitted and not conditional. I just think we're going to open up Pandora's box, and it's kind of late in the game. We've gone down this road 5-6 months, and then start talking about conditional use. So.
I would say one thing: if there's any more evolution to it, and I know this board hopes that doesn't happen, but I think the county made a really bad decision, poor judgment, in not inviting the public in on the meeting at the chamber. We had we didn't have all the stakeholders involved there. We had the hotels, the B&Bs, we had the vacation rental folks, we had some realtors, but we didn't have citizens involved. And it's kind of interesting if you look at this one letter that this gentleman submitted for the agenda item we just had for the rezoning, Jim Hurst, and I thought it was kind of interesting to look at some of his wording here, which I think applies to citizens who are concerned about their neighborhoods being violated with vacation rentals as proposed. Quote, "I have made a very substantial investment in this neighborhood since Buncombe County was zoned. One of the reasons I bought a second piece of land here was because of the existing zoning. The reason for zoning is to protect the neighborhood. This proposal changes the rules to benefit one individual, which could be construed as a few individuals in this case, at the expense of everyone else. That defeats the entire purpose of zoning. If this is allowed, any future landowner can, and he includes, put in vacation rentals without any further permission." And then he concludes what I think very appropriate statement. Says, "Sages from St. Thomas Aquinas to John Locke have argued that the role of government is to provide the greatest good for the greatest number of people. This proposed zoning change offers a dubious benefit to one or a few, but it compromises the quality of life for everyone else in the surrounding neighborhood." And I know Mike Buttram's here representing the Board of Realtors, and I assume he's going to have something to say. But it's a known fact that even among, we've talked about how we don't see the big realtors here at these meetings, and we know why. Because there's a split even within that community. We've got realtors, we've got developers sitting on many, many, many lots in established neighborhoods with restrictive covenants, and they are scared to death of what this might do to the sale of those properties or spec homes. So I will stop at this point and recognize the board's earnest desire to get on and pass this on to commissioners. I would hate to be a commissioner to make this decision. Thank you, Mr. Chairman.
Thank you, Joe. Greg, do you have anything you'd like to add?
I think I concur with sort of what Josh's feelings are. And then listen to what Josh's comments were. I think staff recommendation.
Okay. Michelle, do you have anything?
I think I made it clear last time, kind of where I sat on this. So, no, I mean, I think it's something that's been going on a long time, and I don't think it's a new use. So I'll stand where I stood last time.
Okay. Scott, do you have anything else? I know you spoke
The only
first.
thing is we've received a steady barrage of emails from folks talking about allowing businesses into communities. And the fact of the matter is the existing zoning ordinance allows occupational, residential occupation in all zones. So, I mean, I'm not sure that I buy that argument. I mean, I think this is going to be, as much as anything, something that the commissioners are going to have to come up with a preference on and stick with it. And so, I mean, I think at this point, I would go along with staff's recommendation.
Okay. Well, having heard everyone's comments and informally as a method of polling again, which we've done, I think this is the third time, maybe four. I would like to have staff go ahead and publish the language that you gave us today so that we could schedule a public hearing on this matter. I guess it'll be, would it be the first meeting in September now? Which would be the second Monday.
I think it would be.
Okay.
We'll have to check and count the days for the required number of days of notice.
Okay. Well, I know this is one that doesn't, Mr. Gans and I spoke outside briefly. I mean, this is one that's not going to make anybody happy. But if you would, go ahead and do that, and then we'll target the public hearing for the first meeting that we have in September, which would be the Monday after Labor Day. Is that correct? I didn't look at the calendar right here, but I'm sure.
Yeah, that would be the week after Labor Day.
Yeah.
What's the date?
Hang on, I'll tell you.
12th.
It is 12th? Okay.
12th.
Okay. Now, I will tell you this. I feel like I should share this with you. I talked to Rod Hudgens over the weekend when he called me about the illness in his family and about this. And, of course, Rod still favors some type of conditional use. And I wanted to get that on the record as well. So he's where he was at the last time we met. So, okay. All right. Yeah.
Mr. Chairman, we do have time to advertise for the next meeting on the 15th.
Okay.
Mm-hmm.
Yeah, that's fine. Is that
August 15th?
August 15th.
August
yes.
15th?
30 days.
Just to let you know, well, Scott, Mr. Hughes just told me he wouldn't be here, and I will not be here.
Oh,
How about you, Bernie?
no.
Bernie? So maybe we may not have a meeting on the 15th. Yeah, thank you, Al. Aptly said.
Let's plan on the 12th.
Oh, Lordy.
So September 12th.
Yeah, I'm gonna be out of state, actually.
Me too.
That's better. He is too. Okay. That might need to be under other business, but I'm not going to be. Scott, I just found out both Bernie and Scott were not going to be as well.
We're not going to be able to have it.
We'll have to see if we've got a quorum.
Yeah.
Check it with Rod.
I was going to say the 12th, I won't be here. I don't think
The
that's
next meeting?
the 12th, but not the next meeting, I'll be here,
You will be here?
but not the 12th.
Okay. Well, we'll round up the troops after the meeting, whatever, and we'll find out where we stand with regard to having a meeting at all on the 15th. Anything else? Debbie?
No, sir.
Okay, John, anything? Okay. Next item on our agenda is public comment. I invite you to come forward. Ms. Stiles, haven't seen you in a while. Glad you're feeling better. I think you told me you'd been sick. Good to have you back.
My name is Dee Dee Stiles, and my comment is connected to the first business on the agenda, the people who were requesting R3 so that their children could come to live near them, people who are, the wife is still going to school, the husband has a job, and they can't afford a stick-built house or a modular house. And over again, sitting here, I see this same issue coming up. Older people who need their children to come and live near them, and they cannot afford a stick-built or a modular house, but the property is zoned R1 or R2. Now, gradually, either we're zoning that R3 so that they can do that, or we're not permitting them to do that. But historically, that's how this county has always lived. As you get older, your children come and live near you. And we need to figure out some kind of a way where that kind of thing can continue to happen. because that's who we are in Buncombe County. And I don't know whether you all have to wait for the county commissioners to direct you to do something about that, or whether as a board you can start that discussion on your own. But there needs to be some way, like this young lady who was here today and her father and her grandfather, there needs to be some way that she can put her trailer on that land and start her life near her family on her family's land, even though she doesn't have much money. And I don't know whether we can make a separate category, some kind of like go to the Board of Adjustment and get a waiver to allow a trailer, or however it needs to be set up. We need to stop shutting the door on young people who want to live on their family land. I mean, I'm almost in the same place. I live in the family home, and it's getting so expensive to heat that raggedy old place that we need to put something that my mother and I can stay in the winter that we can afford to heat. But we're in R2. So there you are. What are we going to do? You know? So we need to figure out in this county some way to stop closing the door on people like that young family that was here today.
Thank you.
Thank you, Ms. Stiles.
Anyone else?
Thank you, Mr.
Good morning.
Chairman. Good morning. I hope everybody's doing well. Excuse me. You know how I feel about this proposal. I think I've expressed that opinion enough. I know that you have a barrage of things that are coming through the email. I sent a memo through Jillian that I hope was forwarded on to you, and I hope that you had a chance to read it. There are significant problems. Forget about the issue of whether you want to permit or you don't want to permit. The drafting of this amendment is simply unacceptable. There are so many inconsistencies and so many problems. Mr. Hughes, you were referring to one. Joe is referring to a problem. You know, you read this list, it's just, it's incomprehensible. And for example, here in 13C, it says every dwelling unit. Do you know what a dwelling unit is? Well, dwelling unit is already defined in the zoning ordinance. It says a dwelling unit is a building or portion providing complete and permanent living facilities for one family. What is that doing in this definition? Has absolutely no place in it because the language is wrong. There is an absolute 100% conflict from the language that's here in this conditional use standards and what's in the rest of the document. That is all over the place. And if you look at the memo where I gave you the list of where the inconsistencies are, where the ambiguities are, I think it's going to give you an idea of the tremendous concerns that I have. You know, I hate to keep going back to the subdivision problems. That was a horrific experience for 2 years, only because the ordinance was not clear and incontrefutable. I may not like what your final decision is, and it seems to be that you want to permit it. I don't like that. But if you go ahead and do it, I want to make certain that the ordinance is clear enough so that we have meetings that keep coming up, so you don't have to be annoyed every time there's a conflict that people like me or other people come and say, well, you shouldn't be able to do it. You should be able to say to me, Marcia, I'm sorry, that's tough. That's the way it is. You're going to have to live with it, and here's what it says. And that's what you need to have. I can't emphasize that to you enough. Mr. Hughes, you talked about home occupations. I don't think a home occupation like me working long distance to my law office, sitting at my computer reading deposition transcripts is the same thing as somebody operating a vacation rental. Two completely different things. So I don't think that those are comparable. I don't think this proposal meets the North Carolina Supreme Court tests. It says you have to follow the plan, design, and the objectives before you do any rezoning, that you have to show compatibility and reasonability. I don't think you've done that with this. But again, if I haven't made any progress, and it seems that I haven't, unfortunately, at least please take a very, very close look at the language of the document. And one other thing before I close. How you have come up with allowing vacation rental complexes in Beaver Dam is an absolute mystery to me. Joe said this to you last time. Beaver Dam is not just the valley. I live on a 40% slope on a gravel road. That is not a place where you can have 10 units and have traffic back and forth. It is just not compatible. Please take it out of Beaver Dam. Okay? If there is anything, and I know that I'm not supposed to be here as counsel, I'd be practicing law without a license and get myself into a lot of trouble anyway. But I would be more than delighted to be at any kind of meeting or conference to go over about the methodologies and drafting. I redrafted the South Carolina State Procurement Code. If you think that there isn't a horrific event, that's it. Took me 14 months. And you add in the drafting problems and the political problems, and it was a nightmare. And I turned gray. That's why I color my hair now. But please, you're laughing. That's when it started. When Governor Riley started doing things, I said, okay, time for me to start dyeing my hair.
Thank you, Marcia.
Okay,
appreciate
thanks, fellas.
it. Thank you very much. That's great. Anyone else? Mr. Gans.
Bob Gans, Fairview.
You may need
I'd
to
like to-
you may need to switch microphones. I don't.
Oh, thank you.
Yeah, that one's not.
I want to make sure you hear me. Thank
Yeah.
you. Yeah. Wouldn't want to speak to no one here. I'd like to address a couple of comments that were made by a couple of you gentlemen, in particular Mr. Kessel and Mr. Hughes. Mr. Kessel, I would argue, you made the comment that we'd be opening up Pandora's box if we allowed conditional zoning. I argue just the opposite. I think you're even doing something worse to the residents of our residential community if you open up every zone, in fact, every zone to vacation rentals with no restrictions whatsoever. I mean, as Marcia said, as Joe said, that's the Pandora's box, not conditional. Conditional at least gives the citizens some say and some expectation that they can be heard by the Board of Adjustments, okay? And Mr. Hughes, and I think Marcia addressed this, I'll make 2 points about we already allow some businesses in the communities. Well, first of all, just because somebody might have made a mistake before you doesn't mean you need to make the same mistake, okay? I have an issue with that, sir. Not to be rude. I didn't intend to come across as rude. But the other point is, I think, and I was the president of an association in Texas that had like 2,500 homes. And we didn't allow businesses in communities, but there were some exceptions. And the exception was exactly the one you're talking about. If there's a business in a home that is invisible to the community, why shouldn't the property owner be able to do it? I happen to support that exception, but vacation rentals are not invisible to the community, okay? And as to following up on Marcia's point about Supreme Court suggesting that you guys really ought to be following the plan, I think the intent of the commissioners when they pass zoning is very, very clear in the zoning ordinance. If you look at section 78-640, 1, 2, 3, and I believe, well, ABC and I believe I, which are RLD, R1, R2, and Beaver Dam, it's very, very clear that the intent of those zones, consistent with any kind of land use planning you care to check up on, is that they be residential, not businesses. These businesses harm our communities. You've heard that from a lot of my neighbors and people I've gotten to know as a result of this. And I think you're trying to change the basic intent of what the commissioners passed, and I don't think you should do that, but I think at least if you're going to, you ought to take a look at 78-640 and admit to the world, admit to the commissioners that, yes, we think that was wrong when you guys originally passed it.
Thank you, Mr. Gaines.
Perfect.
Yep, did good. You're trained. You're accustomed to this.
You give me a lot of practice.
Hey, Mike.
Good morning, and thank you. I'm Mike Buttram with the Asheville Board of Realtors. We are a diverse group. Every ideology, every type of business associated with real estate is involved in this group. I'm representing a small group that are members. We had 2 people here that could not speak on their behalf. They both had business engagements, thank goodness, in real estate, which is wonderful these days. The issue, I think, and you're probably as familiar with the Senate Bill 683, the ratified bill, and just a couple of words I think that are important. In no event, this is Section C, in no event may a county do any of the following: adopt or enforce any ordinance that would require any owner or manager of rental property to obtain any permit or permission from the county to lease or rent residential property, real property, except in those rental units that have more than 3 verified violations. I'm sure that there is some evidence that there are violations that take place in the county, but quite honestly, I don't know of any evidence where vacation rentals have hurt anybody. Now, if there's evidence to that fact, then we should discuss it.
I can give you that evidence. I have. Sorry.
And if there is evidence, I think that should be part of the thought process, that when you're talking about an ordinance that has to live within the state statute at this point. So that's an important issue, I think. But more on tempering it with common sense. If you owned a home, as I own a home, that I can't sell, it's been on the market for 4 or 5 years, it's in a nice leafy subdivision of Asheville, I chose to rent it so that we could hold on to the investment of 34 years. Can't sell it. What do I do with it? And it's not a vacation rental in this case. It could have been, but it's rented as a non-vacation rental. What are you going to tell those people that are trying to hold on to their investments? What are you going to tell yourself if you get to that position? There's a common sense aspect to it. I think that in this case, one of the gals had 2 vacation rentals. It's in open use. She would be required, under the current circumstance, the way she's reading it now, she couldn't vacation rent, but a complex could go into it. A vacation complex can go into it. I think the bottom line, and I think a lot of people have made some very, very good points, I think that I would hate to say start over because there's been too much work going down that road, but there is some evidence that you should look at this, and I think like any reasonable person that anyone's going to follow the rules, assuming that the rules are followable, that we understand them and we can deal with them. Thanks.
Thank you, Mike. Appreciate it. Mr. Comfort.
Al Gumpert, Buncombe County. I don't think any of us would want to deprive somebody of the right to lease out their house for 6 months, a year, because they've had a work transfer, because they've, whatever, family circumstances. But that's not like renting their house every weekend to different people. That's an impingement upon my rights as a neighbor. So here we have the majority asked to subsidize those folks who have chosen to invest in residential real estate for the purpose of running a business and making a profit. And there is no way that it belongs in R1 or R2. And this whole ordinance change is a very bad idea. And what it's going to do is make a lot of money for a lot of lawyers, because all of us are running around figuring out how we can change our covenants to prohibit this kind of thing. And we shouldn't have to do that because we have zoning, and it's supposed to protect the majority of us. Thank you very much.
Thank you, Al. Patty, did you have anything you wanted? I believe we covered all the bases. Okay, we will now close the public comment portion of our agenda. Yes, Johnny.
Just before you adjourn, given that 3 members are going to be not available for the next meeting, and we don't have any subdivision or rezoning requests for the next agenda, we're going to go ahead and cancel that if it's okay with you guys.
It's okay with me.
Get ready for school.
Yeah. Sounds like a good idea.
Move to adjourn.
We have a motion to adjourn? Yes, go ahead.
Got one other item I'd like to get.
Sure.
I'd like to compound on what Michelle said earlier. I'd like to ask staff, this morning with this girl, I think that was a tragedy. And I don't know if there is a way, and I don't want to call it a loophole, but a gateway for family members or something. I just think in this economy, we're going to see more kids needing to live where mom and dad are, and I think we're going to see more mom and dads needing to live where the kids are.
Mm-hmm.
And I don't want to stand in the way of that. I just, like I said, I think that was a sad thing. And, I mean, I understand the resistance and what mobile homes do, but is there a way, I guess is what I'm asking, and is there a way we can push this up and make it something for us to address?
Okay.
Mr. Chairman, may I ask a question?
Yeah.
I don't know if this is a possibility. I have to agree with you. I think they should have a way. Could they request a variance to just allow them to do that one thing?
You cannot ask for a variance in use.
Has to be spot zoning.
Cannot ask
No,
for a variance in
legally.
use.
Yeah. Okay, anyone else? We have a motion to adjourn. Do I hear a second?
I'm going to follow him up. Let that fly by. Nice job. I think that we can, as a board, if it's something we want to do, submit something or a request to them to look at this again. And I've constantly said that, that I think the commissioners need to take into account some way of conditionally, permitting, and I'm not sure you can do that. You said you can, or some kind of way to allow at least the double wide standard that was there prior to the zoning change in the second time. That was a standard that had a house that seemed to be acceptable in its look and feel and standards to where a lot of people agreed with it. And I'm going to tell you, we cannot relegate people who are poor to trailer parks. And that's what this does. I mean, really, that's what it does. And it's not what it meant to do, I'm sure. People don't like the way they look, but that's what it does. The only option that these people have is to move into a trailer park. And if you don't want trailer parks in this county, don't encourage the growth of them by not allowing them to be able to do exactly what we said no to today. So, sorry. Thank you.
Okay, thank you, Michelle.
Before we adjourn, did I hear that the August 15 meeting is canceled?
That is correct.
The next meeting is September 12th.
That is correct,
After
Joe.
Labor Day. Okay.
Yeah.
Thank you.
Okay. We have a motion. I think it's second by Joe. Was that a second?
I'll second that.
You'll second that? Okay. All in favor, say aye. Meeting adjourned. Thank you very much.
Not me.
Tom, did you make the motion to adjourn?
No, Scott did, didn't he?